Hello, and we are here with a new episode with eminent senior advocate, Supreme Court of India, Subodh Markandeji. Today we will be discussing on one of the most important topic of the Constitution, that is basic structure. The motive of this channel to spread awareness about ongoing legal issues, statutes, matter, and other legal tests. On this topic, my first question is: what is the doctrine of basic structure of the Constitution? So from here, you can explain the basic structure of the Constitution, sir.
A basic structure of the Constitution is a doctrine enunciated by the Supreme Court of India in the most celebrated case of Keshavananda Bharati versus State of Kerala, 1973 supplement SCR, page 1. So the whole volume is nothing but Keshavananda Bharati. This judgment runs into more than 300 pages, maybe more, and it is rated as the leading contribution, I think most outstanding contribution that Supreme Court of India has made to the development of constitutional law. And it has been followed ever since it was enunciated, including by those judges, of the Keshwanan bench who had dissented. They had also followed this case. And Supreme Court of India has never deviated from uh, this declaration of law, and it has been found to be so outstanding that many countries are following that doctrine because it ultimately saves the constitution from destruction or damage. So in Bangladesh, this has actually been incorporated into the constitution itself. But other countries like South Africa and Malaysia and some other countries are also following this doctrine. This encyclopedic case is a detailed exposition of the interpretation of Article 368 of our Constitution relating to the power of Parliament to amend the Constitution. Now, by a majority of 7 to 6, the 13 judge bench of the Supreme Court held that even at its widest, the power to amend the Constitution cannot destroy or damage the basic structure of the Constitution. As to what is basic structure, the judgment said this. Uh, so, basic structure is comprised of sovereignty, unity, and integrity of the nation, the supremacy of the Constitution, supremacy of the Constitution. This in our scriptures also we find that even the king has to follow the dharma. So this is completely in accord with our ancient ethos. Then republican and democratic form of government, secular character of the state, separation of power between legislature, executive, and judiciary, federalism, that is to say, the sharing of powers between the Union of India and the states. Then dignity and freedom of individuals secured by fundamental rights under Part 3 of the Constitution. The mandate in Part 4 to build a welfare state and parliamentary democracy. Now, the court has, various judges have held, those 6 judges who enunciated this document, the leading judge being Justice H.R. Khanna. So they have held that these are broad features and are only illustrative and not exhaustive. Now, as I said, the Supreme Court has ever since then consistently followed its 13 judge majority judgment without ever deviating from that. As I said, even the judges who had themselves dissented in Keswananda Bharati's case followed this doctrine in a case called Indira Gandhi versus Raj Narayan that has been reported in 1976 to SCR 526. I'll give a few more cases in which I was also associated. First 2 cases, Minerva Mills versus Union of India. I had the occasion to assist the uh, Solicitor General of the day, I think. I don't exactly remember. Maybe he was Attorney General, Mr. Lal Narayan Sinha,
Yes, sir.
appeared in this matter for Union of India in Minerva Mill, and there was another case immediately following this, that is Vaman Rao versus Union of India. I had the occasion to appear in these two cases, and the court further, took this doctrine forward. Then there is a case called Quixota versus Zikihillo in 1993, and then very famous case called S.R. Bomai versus Union of India in 1994. Then S. Chandrakumar versus Union of India of 1997. So there are so many other cases which have followed. Maybe I have not been able to enumerate all of them.
So it's okay, sir. So can you explain, sir, why is the doctrine important to the functioning of our constitution?
So uh, constitution is sacrosanct, unless absolutely essential, we should not touch it. And it must not be amended merely on whim. Yes, the governments face problems. Of the day face problem because they have to work in constitutional framework. But it should be resorted to uh, sparingly. That's all I can say. But what has happened is that the governments of the day started tampering with the constitution. So within 1.5 years of the inauguration of the constitution, the first amendment was brought. And the process of amending the constitution has never stopped. More than 100 amendments have been made in a span of 75 years. Now, merely by following the procedure which has been laid down in Article 368 by itself cannot save the constitution from destruction or damage. During the emergency, Indira Gandhi's government had enacted very grotesque and abominable amendments, which I cannot discuss here because they require some discussion. So it was in that background that the doctrine of basic structure was enunciated in 1973, because the constitution was in the uh, in the grave, uh, I would say, there was grave grave possibility. The kind of amendments which that government brought made it quite clear that constitution can be, amended by that government beyond any recognition. So the doctrine of basic structure has in fact, saved our constitution. And there has not been major difficulty. Who can say India should not be democratic, India should not be republic, India should not, all those ethos are well
Yes,
known.
sir.
They are part of our, polity, part of our functioning, part of our constitutionalism. So uh, naturally, the court has followed, and it certainly put a damper on enacting amendments that could destroy or damage the constitution. Therefore, the power of judicial review of all constitutional amendments is a sure guarantee for protecting and preserving the constitution.
Sir, but this doctrine is nowhere mentioned in Article 368, which deals with the amendment of the constitution. Sir, can you further elaborate on this topic?
You are right that it's not mentioned in the constitution. Everything is not in the constitution, but some, as I said, uh, Bangladesh has incorporated it into its constitution itself, that basic structures can never be changed, because it it's good. It will be, those are eternal values. Therefore, the absence of mention in the text of constitution is not determinative.
Yes, sir. So on that logic, can we criticize the collegium system of appointment to the Supreme Court and High Court?
Uh, the comparison is somewhat odd. That's all I can say. See, in the case of collegium system, when though Supreme Court has enunciated that have actually, set up this collegium system. That's the problem. So this collegium system judgments have read into, two articles. That is Article 124(2) and 217, dealing respectively with the appointment of judges to the Supreme Court and High Court. So they have put, uh, those collegium is nowhere mentioned in the constitution. That is true, and that is what is causing a lot of problem. And those existing words has the effect of limiting the exercise of executive power of the president to appoint judges to the Supreme Court uh, and the high courts. Those words do not exist in those articles. That is true. uh, but uh, some doctrines are part of the constitution. While doctrines are part of the process of interpretation, this is causing problem because uh, the collegium is nowhere mentioned. So this collegium system is, that either you should define in the constitution itself that this is what collegium would be. So these are, hampering the process of executive power by the president. So that's the problem. Now, so far as the doctrine of basic structure is concerned, you will appreciate that the very process of construing and interpreting the constitution and the laws, uh, they involve the application, concurrence, dissent, following, distinguishing certain doctrines. Like I'll enumerate some doctrines: doctrine of acquiescence, doctrine of ancillary powers, doctrine of blending, doctrine of conversion, doctrine of eclipse, doctrine of adjustum generis, doctrine of estoppel, doctrine of necessity, doctrine of peridelicto, doctrine. Now, this pith and substance is actually a constitutional doctrine. It has come from Australia. So, whenever you construe the power of the federation or center or union or whatever you may call, and the units, that is states or provinces, then this doctrine is pith substance is invoked to find out whether in pith and substance this particular item follows of falls within the purview of the federation, that is to say union or center, or it falls within the purview of the province or state or whatever you are calling. Therefore, the comparison is not very apt. That's all I can say. We should organize an episode on collegium system and discuss it in broad outline so that we understand whether constitutionally that is valid, or whether they should define what is collegium and all this.
Thank you, sir, again, sir.
Yeah.